When we divide property in a divorce in Texas, Texas is a community property state. What that means is the court presumes that all the property owned by the parties at the time of the divorce belongs to the community. When we talk about community property, it's easy to think of the house. If we bought the house during the marriage, both parties have a community property stake in the house. But it really also means much smaller things. It means the cars. It means the toaster. It means, the refrigerator. It also means income. Spouse one, their paycheck comes into the bank, when they get paid. Spouse two, their paycheck comes into the bank when they get paid. That's all community income. And it does not matter if spouse one has his own bank account and spouse two has her own bank account. It's still community money. We keep our accounts separate. Okay, maybe you do keep your account separate. The court doesn't. Your money and his money, all that is the same. It's all in the community. How y'all manage it is up to you, but the money is all community. Retirement accounts, likewise, are community assets. So that is a real heartbreaker for people when they come in to get a divorce and they say, what about my retirement? Can I keep my retirement? It's not your retirement. It never was. It was y'all's retirement. But I worked there my whole life. I've spent all these years working at this job, and I've built this retirement, and I need it. All the retirement that you made during the marriage is community property. So it was never your retirement just because it was attached to your job. Community property is the rule. If you want to show that something was your separate property, you've got to show that you owned it before the marriage. You've got to show that you inherited it during the marriage, or that it was a gift to you during the marriage. So we see people, they'll buy, they'll give each other a pew-pew for a gift. And so come divorce time, they'll say, well, that was a gift to me. I got that at Christmas time. Okay, well, that would count as your separate property. Think about those car commercials at Christmas time, right, where the spouse comes out and there's a new car in the drive and there's snow everywhere with a big red bow on the car. Is that bought during the marriage? Yes. Is it a gift? Yes. It appears to be a gift. It's got a big red bow on it, but then it gets paid for out of the community account. So was it really a gift, or was the gift kind of a show? That gets complicated, and we just have to argue that out. When it comes to community property, ideally, it's relatively simple. Anything that you acquired during the marriage is going to be community property, and it's going to be divided as community property unless you can show that it was your separate property. And the burden is on you to show that something was yours before the marriage, or you inherited it, or it was a gift. A common myth that people have in their head is that when we start dividing up the marital estate, that they should get their 50% share. I just need to clarify something for all y'all out there. There is no provision in the Texas Family Code that says the spouses are entitled to 50% of anything. What the code says is the parties are entitled to a just and right division based on all the facts, based on the behavior of the parties, based on whether one party is a stay-at-home spouse and the other one makes a ton of money. Based on all the facts, what is a fair split then? That's why the code doesn't ever talk about a 50-50 split. It talks about a just and right division. So under the facts, 50% split could be great. Under the facts, a 60-40 split may make more sense to the judge. We start talking about how do we divide the estate. Well, I want my half of his retirement, or I want my half of the house. There's nothing that says you're entitled to a half. Now, when we're working negotiations and we're trying to settle a case, we often start with the presumption that a 50-50 split is going to be easier to get an agreement to. So we often negotiate from the position of how can we get to about a 50-50 split. Now, do keep in mind that we're going to split the entire estate, not each individual asset. It's entirely possible that if there's $100,000 in equity in the marital home and the wife wants to keep the home, and there's $100,000 of retirement account and husband wants to keep the retirement account, we can make that happen. We could split that way. Wife keeps the house with her $100,000 in equity. Husband keeps his retirement with $100,000 in that account. And ta-da, you have like a 50-50 split without having to split those assets. So we're always looking for a way to reach an agreement so that our client can take their destiny in their own hands. They can control their own outcome. I find that a lot more empowering than just taking the entire case to the judge and letting a judge who doesn't know you, doesn't know your situation, you put on your case, you have a few hours, and then the judge at the end just says, all right, here's how I'm going to split it. And then you live with that. There's nothing in the code about a 50-50. We often do start negotiations from that point of view. But if it goes to the judge, the judge very often will split things and start dividing assets in a way that makes sense to the judge, or is just the easiest under the family code and not necessarily what's the easiest and best for the clients at the end. A big surprise for a lot of folks is that pleading adultery in your divorce pleadings doesn't help you very much. Texas Family Code works to divide a marital estate without punishing people, okay? Family court is not where you get justice. Justice is a criminal court type of idea. What we're looking for in a family court is to get you on with the rest of your life. Imagine a family court case, a divorce is a business transaction, right? It's not a criminal transaction. It's a business transaction. The court almost looks at your property division as if you and your spouse are business partners together, and now the business is being dissolved. If you and your spouse were just business partners and you owned a rent property or two, and you went to a civil court to figure out how to divide the business because now y'all are dissolving the partnership, the court would award property and deal with the debt and everything else, and then the two business partners will go on their merry way. The divorce court is very much like that. The court presumes you are unhappy with each other. That's why you're getting a divorce. So if you come in and say, yeah, but we're only getting a divorce because she cheated or because he had an affair, the affair doesn't shock the court sensibilities. Number one, he's seen it 1,000 times. And number two, it doesn't matter. We already know you're unhappy. The affair is just a byproduct of the underlying unhappiness. And so the court is not going to punish the other spouse for being a cheater. Does adultery ever matter in a case? It can, and here's how. Imagine a kind of stereotypical high-powered executive type who's got a stripper girlfriend who, and he's over the course of a few years has paid thousands and thousands of dollars because he's paying her apartment or he's buying her a car. When wife finds out that he's been spending money on the girlfriend, the court can claw back some of that money. If he spent $50,000 on this girlfriend, the court can help the wife claw back her community property share, so maybe $25,000 or so. If we could prove he spent $50,000 on the girlfriend, we might be able to claw back $25,000 of that back in the wife's column. So in that situation, the adultery could help the wife. Let me give you an alternate example. A wife has an affair with, the pool boy, another stereotypical, super cliche example. But imagine that husband comes home and finds him and he files for divorce and says, she's been having this affair. Well, guess what? She didn't spend any money on the pool boy. It's just a fling that happened and there was no money spent. So there's no money to claw back. So when we talk about an adultery cause of action, when we're saying, hey, we're filing a divorce and the other side committed adultery, understand that may be useful to claw back money that was spent. But if there was no money that was spent, it's not going to have a value to you in the divorce because it doesn't shock the judge. Do we sometimes plead adultery? Sure. Does it give you some tactical advantage or some strategic advantage in the case? No. Most people who have affairs, they don't spend a lot of money on it, so there's nothing to claw back. So the adultery hurts their feelings, and it embarrasses them, and it make them want to fight harder in your divorce. But as far as the court doesn't care.